Well, thank you very much, Professor Shaughnessy, for the kind words. I really appreciate that. And I want to also thank Professor Matthew, Professor Jost for agreeing to comment. I know especially travel for both of them, even for Professor Jost. I appreciate them being here, and the Law Council as well. Thank you for being here. And yes, it is difficult to pronounce Q-U-I-T-A-M. I eventually settled on one method of pronouncing it, but definitely don't hold it against me if you feel that it's an incorrect pronunciation. But when I was writing my note on those things, people would ask me about my topic, and I would tell them that I'm writing on key term actions under the False Claims Act. I could literally see their eyes beginning to glaze right in front of them as I was talking. So I knew I needed a shorthand in English, and I knew I needed a more human interest way of explaining what this topic was about. And that's when I realized that actually, Professor Shaughnessy actually stole a little bit of what I was going to say. The note is essentially about whistleblowers. It's about those that observe, recognize that fraud and corruption is going on, typically in the workplace, in healthcare, defense contracts is another big area, and they alert the authorities that this fraud is taking place. Now, the problem with whistleblowers is that if you have the wrong kinds of people blowing the whistle, things can get really noisy. Things can get a little confusing. And it makes me think of a particular episode in what I think is one of the greatest TV shows of all time, which is Arrested Development. Now, in the scene that I'm thinking of, Bluth company president Michael Bluth is at a board meeting for the company, and he's trying to explain how he's not like his father and his corrupt practices, and he wants an open and honest company. He wants a company full of whistleblowers. And to illustrate his point, Michael dumps out a box of whistles all on the boardroom table. And what he finds out is that can be counterproductive because the meeting quickly devolves into a bunch of needless whistleblowing, and nobody can really tell what's going on. And so in frustration, finally Michael is forced to try to salvage the meeting by recalling everybody's whistles. Now, in the case of the False Claims Act, or FCA, whistleblowing can not only be noisy, but can involve huge sums of money. By the way, the phrase, Professor Shaughnessy touched on it a little bit, but the Latin phrase, however you're going to say it, it's short for a longer, even longer Latin phrase, so I'm not even going to read that one. But it essentially means one who pursues on behalf of our Lord the King as well as his own behalf. And the essence is a qui tam relator or whistleblower under the False Claims Act can recover 15 to 25% of a recovery that the U.S. government makes by blowing the whistle on fraudulent activity. Now that's a huge incentive for relators to come forward and expose fraud, because if you take just last year, 2010 fiscal year, the U.S. government recovered $3 billion in False Claims Act cases, including settlements from giants like Chevron, Hewlett-Packard, and Northrop Grumman. So the incentives are huge, and the statistics also show that fraudulent activities from contractors and false claims being submitted to the government cost the government a lot of money. So incentivizing these relators, these whistleblowers, to come forward and report fraud, especially if they have insider information about it, is key to cutting down fraud against the U.S. government. But this is only true to the extent that these whistleblowers, these relators, provide useful information that benefits not only the government, but ultimately us as the taxpayers in the end result. And this hasn't always been the case with actions under the FCA. In fact, the FCA has had a long and tumultuous history, swinging through various extremes of use and disuse, and courts have had a very hard time sometimes pinning down who should and shouldn't get paid. And my note examines this history, looks at the inception of the False Claims Act all the way through the 2010 Affordable Care Act, and tries to set a roadmap and try to provide a solution for how to go forward with incentivizing the right kind of whistleblowers while eliminating parasitic and opportunistic lawsuits. All right, so the FCA, or the False Claims Act, where did it come from? It's a very old statute. It goes all the way back to the Civil War, where it was nicknamed Lincoln's Law, because it was designed to prevent fraud against the Union Army by contractors who were selling defective goods to the Army. Congress set a goal of using co-conspirators to rat out their friends to reveal fraud. In Congress's words, they wanted to use a rogue to catch a rogue. Well, the problem was they didn't catch many rogues. And the FCA fell into a long period of disuse till about the 1930s and 40s. But with the New Deal era, large increase in federal government spending, increase of contractor involvement with the government, there was not only rampant chance for fraud, but also rampant chance for whistleblowers to come forward and sort of cash in on that. And the problem is that era was known for its just abuse of the qui tam provision. Just mention one example briefly. It's sort of considered the high water mark of this era. It's a case called United States ex rel, or by relation of Marcus v. Hess. And in Marcus v. Hess, what happened was Marcus, the plaintiff, essentially copied an existing pending criminal indictment against a fraudulent contractor. Copied the indictment, based his civil action on that indictment, went to the court and said, I should collect some of this, some of the recovery for this case. The case went all the way to the Supreme Court. The government argued that he shouldn't be able to share in this recovery, that Marcus shouldn't be able to share, because it was all derivative. He was not a source of the information. He copied it from an existing indictment, and the government already knew everything that could be useful about that case. However, the Supreme Court took a very strictly literal, almost formalistic interpretation of the FCA and read the text and said, we don't see any of this limiting language that you guys are talking about. So yes, despite the fact that he copied this claim from an existing criminal indictment, Marcus does get paid. And they said, Congress, if you feel that this should be changed, then that's up to you to amend it. So very quickly, in 1943, it was just a year or two after that, Congress did amend the False Claims Act, and they amended it to bar those kind of claims that were derivative based on information that was already existing in the public domain. And that became known as the public disclosure bar. In other words, the information is publicly disclosed. You can't bring a qui tam action and expect to get paid on it. So Congress thought it had done its job, sort of dusted off its hands, and unfortunately, that set the pendulum swinging too far in the other direction. Because now the False Claims Act was being underutilized, and the public disclosure bar was actually not only preventing the sort of the piggyback lawsuits like Marcus v. Hess, but it was also preventing useful, beneficial lawsuits. Now, the sort of low point of this era is another case, just to use one as an example, is a Seventh Circuit case from the 80s called Wisconsin v. Dean. Alice Dean was a medical doctor in Wisconsin in the 80s who was charged with submitting false claims for Medicaid reimbursements. Now, she was facing criminal charges, but the state of Wisconsin also brought civil action under the False Claims Act to try to share in the recovery. And they knew, of course, about the public disclosure bar. They knew that if the information is public, you're typically not going to be able to recover. But Wisconsin's theory was, look, we provided you this information. We're the source. You know about it because of us. Shouldn't there be an exception so that we can share in this recovery too because we've benefited you, the federal government? Well, it may seem like a reasonable argument to them, but the Seventh Circuit wasn't buying it. The Seventh Circuit, much like the Supreme Court in Marcus v. Hess, the Seventh Circuit took a very strictly literal view of the public disclosure bar and said, you know, we don't see this exception that you're talking about, and if you want that exception, our hands are tied, maybe you should ask Congress. Well, 2 years later, in 1986, Congress did provide the exception. The new language after 1986 read that no court shall have jurisdiction over an action that's based upon public disclosure of allegations or transactions, and they list several ways that the allegations could be made public. And then they conclude, unless the action is brought by the Attorney General or the person bringing the action is an original source of the information. So just to recap briefly, you have the original Lincoln's Law, but they didn't catch very many roads. You had the abusive period during the New Deal, where you had too many qui tam relators running around filing lawsuits. You have another low point because of the public disclosure bar. And now you have the 1986 amendments. Congress, again, brushed off its hands, thought we should be good. We set the right balance. We're striking that golden mean. We're going to incentivize good qui tam relators, and we're going to screen out parasitic piggyback lawsuits. Well, again, Didn't quite work out that way, because instead of solving the problem, the original source exception, as it became known, instead sparked a circuit split among the federal circuits over what exactly constituted an original source. And they actually used air quotes in oral argument during all of this. Now, not to get too bogged down on the details, because as Professor Shaughnessy said, there's a lot of case law to review. But what I did in the note is break up the circuit approaches into 3 different camps. So the different federal circuits fell and aligned themselves in 3 different ways. What I've termed the permissive approach, which is the First and Fourth Circuit. The restrictive approach, which was taken up by the Second Circuit and the Ninth Circuit. And then the middle ground approach, which surprisingly falls in the middle of those 2, and that was taken up by the DC Circuit and the Sixth Circuit. Now, just to recap those different approaches very briefly, the permissive approach took a very little reading of the 1986 amendments and said that as long as you provide your information to the government before you run to the courthouse, you can still be considered an original source. Now, the restrictive approach added a new requirement that they believed was implicit in the legislative history and public policy behind the 86 amendments. And that requirement was that in order to be considered a true original source, you must not only reveal your information to the government before filing your suit, but you also have to be part of the leak that made that information public in the first place. So under the restrictive approach, an original source would be not just a source to the government, but a source to everyone else as well. And finally, you have the middle ground approach by DC and the Sixth Circuit. The middle ground approach didn't agree with the extra requirement that burden placed by the Second and Ninth Circuit. But they did say that if you provide your information to the government, you want to still be considered an original source, you must still outrace the public disclosure. You have to make sure that you inform the government before the government itself can just pick up the New York Times and read it. So, in other words, for the restrictive approach, you have to be the leak, and for the middle ground approach, you just have to beat the leak. Now, after the 86 amendments and the circuit split and the different controversies that spawned, we then come to 2010 with the healthcare reform and the Affordable Care Act. Now, much less publicized than many of the more highly debated parts of the Affordable Care Act were some interesting changes made to the original source exception to the public disclosure bar. And I'll just read briefly what the Act did to change that definition. The Act defined original source, and I'm told Obama himself used the air quotes, as the following. For purposes of this paragraph, original source means an individual who either, 1, prior to a public disclosure, voluntarily disclosed the information to the government, which sounds very similar to the middle ground approach, or, 2nd, has knowledge that is independent of and materially adds to the publicly disclosed allegations or transactions, and who has voluntarily provided the information to the government before filing an action under this section. So basically what the Affordable Care Act did by changing the definition of original source is it substituted a disjunction. You now have this or. You have 2 ways to meet the definition of original source. You can take what was previously the middle ground approach of making your, informing the government of your claim before filing suit, but making sure that you do that before it becomes public. Or there's this second phrase now, this new language from the Affordable Care Act, knowledge that is independent of and materially adds to the publicly disclosed material. Now, what my note seeks to do is address this new definition in light of the past circuit split and the way courts have handled the original source exception in the past. And what I did, in addition to that, was consider empirical evidence, empirical data, and to see how that should influence how courts should look at it. And my note generally agrees with prong 1. I found prong 1 to be very helpful and a good step in eliminating parasitic and piggyback lawsuits because it's not as stringent a requirement as the Second and Ninth Circuit, but it still requires that a key tam relator provide information to the government before the government could simply turn on CNN and get it. And I thought that was a step in the right direction. Then second, my note addresses prong 2 of the ACA's new definition of original source. And then I do argue that some ambiguity still clings to those terms in prong 2 and try to use empirical evidence to suggest where courts should go from here. Now, I will get to the proposal in a second, but I do want to just pause first to talk about some big picture concerns, sort of some overarching themes at the root of the False Claims Act. Now, first is to keep the big picture. While we should reward key TAM relators for bringing fraud to light, we shouldn't lose sight of the fact that the FCA ultimately exists to help us, taxpayers, save money. And to the extent that key TAM actions under the False Claims Act can do that, then fantastic. But to the extent that we encourage parasitic or opportunistic litigation, we're not being true to the original intent of the False Claims Act, and we're not saving ourselves any money in the long run. Now, Richard Opperell has observed that the FCA is just as concerned with deterring parasitic claims as it is with fostering productive suits, and that was something that I was keeping in mind a lot as I was formulating my approach while writing the note. Now, the second thing to just consider here before getting to my proposal would be empirical. Now, data shows that the rate of parasitic key TAM actions is quite alarming. And according to the numbers from the Department of Justice, the Attorney General doesn't intervene in the majority of key TAM actions as they are allowed to by statute. And what my note argues is that key TAM actions in which the Attorney General intervenes have a far greater rate of success and a far greater likelihood of merit. And so the fact that the Attorney General declines to intervene in most of these actions really brings up some concerns about the legitimacy of a lot of key TAM actions. So further, data about the outcome and the disposition of these key TAM cases is also alarming. And there's a reason to connect, just as we said a second ago, that there's a reason to connect the Attorney General's involvement in key TAM actions with the merit of the claims. Also, there's a legitimate reason to connect the success of key TAM actions with the underlying merit. And obviously, it's a lot more detailed than I'd be able to go into here, but my note looks at that, looks at that evidence as part of my overall proposal. Now, faced with these concerns, what my note proposes is that the courts take a very cautious construction of these terms, independent knowledge and materially adds to, in the new definition from the ACA. And my note essentially argues that these terms should be understood to refer to a plaintiff's knowledge of valuable information that substantially assists the government's case. And in cases where allegations of fraud are public, they've been made known publicly, only relators that can substantially assist the government's case, not whistleblowers who stay silent until they can smell a defendant's blood in the water, may join in recovery under the False Claims Act. So, in closing, I do want to go back briefly to what I said about the big picture. Last Sunday, Steelers kicker Sean Sweeson, with 4 seconds left on the clock, kicked the game-winning field goal for the win over Indianapolis. Now, just imagine for a second that after he kicks that field goal, the second-string kicker runs on the field to join in the celebration. Who's more deserving of a reward, the kicker or the backup? And to switch back, at the risk of using too many metaphors, to switch back to the whistleblower metaphor, it just makes more sense to reward whistleblowers that actually contribute to recovery of fraud for the U.S. government and for the taxpayer. The point of the False Claims Act is to incentivize those kinds of whistleblowers. And as the Second Circuit, in one of its decisions, aptly put it, a whistleblower sounds the alarm. He does not echo it. Thank you.
Well, the False Claims Act is a topic about which I feel passionately, and you can tell that those of us that have been debating this for years all feel passionate because we all use metaphors, and I'm going to roll right with Chris, and I'm going to bring you some metaphors because this is quite a topic that I really care a lot about. I want to reiterate, first of all, my thanks for the opportunity to come back to Virginia. Virginia was home to me for 10 years. down the road at the law school that I think should remain unnamed for the moment. I both went to law school and started teaching there and got the opportunity to fall in love with this state. So as soon as the plane landed, I sort of started just really recapturing my warm feelings for the rolling hills and the green landscape. It's beautiful, and I really thank Mallory and all of you who put a lot of work into this and bringing me back to Virginia. It's a beautiful place, and I love being here. I have friends here like Robin Wilson and Timothy Jost who are in my field and with whom I have had the pleasure of growing up as a health lawyer, and I am grateful for the opportunity to visit with them again. But most of all, I'm really grateful for the opportunity to read Christopher's note, because it is quite frankly no wonder that he won this wonderful, prestigious award. It is a wonderful note. I, of student notes, expect much less than Chris delivered. I love student notes because they aggregate the law that's current, and I can always find all of the detailed law on a particular topic when I find a student note that's very well done. I also love student notes because if they are well done, they usually have the added advantage of showing up very lucidly a silly mistake, like where the law has really done a bad job. And Christopher has done that as well. I very seldom go to a student note for a new idea that I think, aha, that's workable, that's something the courts really ought to look at. Because that's a lot to ask of a third-year law student. It's a lot to ask to say, come into a field where there's a lot of discussion already going on and bring us a new idea. Not only a new idea, but a new good idea, and Christopher has done that as well. So this has been a wonderful opportunity. And then lastly, I love this note because it cites my work with approval. And I appreciated the introduction because you made reference to my many articles on race in the law. I have a lot of articles on the qui tam, 4 years of Latin tells me that's the right way to say it, the qui tam provision of the False Claims Act, and nobody cites my work with approval on that. So I'm very grateful, and I think you're absolutely just brilliantly reasoning when you the note. Okay, I want to focus on this phrase that Chris referred to from the Act's inception. Use a rogue to catch a rogue. That was the original intention. Use a rogue to catch a rogue. A co-conspirator is to blow the whistle, is to tell on the fraud that's going on in his or her knowing, because he's an insider, she's an insider, and she has a good idea of what the government can't see. And the government's shorthanded. The government doesn't have enough people to catch all the fraud that's going on. And fraud, let me say right up front, is a bad thing. I think it is bad that people commit fraud, and I think we ought to go after fraud, and I think fraud should be stopped. This is not a talk about how fraud ought to be allowed to run rampant. And so if the idea of catching fraud and fighting fraud on the government is the core of the qui tam provision, then the incentive, let's say the incentive is, as Chris has pointed out, it is a vigorous incentive. So the way the qui tam provision works, just a little bit of procedural background so that you know, the real carrot here is that the qui tam relator who brings evidence of fraud and gets past the public disclosure bar, as Chris has pointed out, gets an opportunity to share in the damages that are recovered times 3. Right? So treble damages are a lottery jackpot, right, in terms of incentives. When you think about the possibility as a plaintiff, a qui tam relator, of finding fraud in your state, let's say because my concern is healthcare companies, a hospital. I'm a 300-bed hospital, right? And I have however many patients come to occupy my 300 beds a year, and I do, my surgeons do appendicitis, they treat appendicitis. And if the fraud occurs every time I have a surgeon bill incorrectly for appendicitis over a 10-year period, and I add each of those incidents penalties for each of those incidents to the tune of $11,000 per claim, per patient who gets an appendix removed at my hospital. And then I treble it and give you 1/3 of it? Why work, right? This is a really good deal. So the incentives are very strong for key TAM relators to show up and find fraud and report fraud. So as you've heard, the idea of fighting fraud in the government is incentivized strongly. Saving or recovering money that was fraudulently taken from the public fisc, as Chris said, protecting our funds as taxpayers. This is a strong and important reason for the existence, an underlying motivation for the act. Add to that the government is in the business, we think, of enhancing the integrity of systems, of people who are their contractors, whether they're defense contractors or in the instance I gave, healthcare contractors. The government is concerned with making sure it pays people to be honest, and that the people it pays are honest also. Where healthcare is concerned, and you'll see in a moment why I'm focusing on healthcare so much, not just because it's my concern, but because it really is one of the drivers of the key TAM statute in operation. Where healthcare is concerned, there's the added policy objective of containing costs, right? We are experiencing, again, near double-digit inflation, and the cost containment objective of making our health care system work better is a laudable, important, and central objective of how the key TAM Act, or the key TAM portion of the False Claims Act, operates now. I have still got several problems that I think are relevant and important to how this operates, and Chris gives me an opportunity to once again tell you about them. In a nutshell, I'm worried that instead of fighting fraud, all the government and key TAM relators are doing is alleging fraud and collecting up money, having done that and that alone. So if that's the case, then we're really not reducing the amount of fraud that occurs. If you end up agreeing with me at the end of the day, then we're not even returning money that has been wrongly taken from the public fisc, right? This is, I'm going to argue, now I'm going to get with my sort of passionate analogies. This is a rogue squadron gone wrong, right, in a lot of ways, and Chris points this out. The prosecutorial methods that are used by the government in order to identify those targets that it will join, those key TAM relators who are actually filing suits serious enough, strong enough, good enough for the government to say, I will become a co-plaintiff with you, are very small. Right? The number of suits that key TAM relators file, and the government looks at it and says, I think I'll let you prosecute that case. I'm going to sit this one out. Chris uses that number, or that disparity, as a proxy for the number of suits that are actually valid. Right? That the number of suits that are actually solid enough claims for the government to pay attention to. How the government identifies those suits has very little to do, in my estimation, with what we would analogize to sort of a probable cause kind of finding in a criminal setting. Now, this is not a criminal setting, but having a substantive reason to go after these targets is not what the government does. If you go to conferences with the government on one side and then lo, me on the other side, what the government will confess is that very often all they do is run a computer program to figure out where there are aberrational patterns in billing, a blip, a very big number, sort of a weight that they didn't expect. And here's the problem with that. Merely alleging fraud, right? Just merely saying you are now the target of a fraudulent allegation of fraud under the False Claims Act. Because of treble damages, because of the math that I did really simply before, the mere allegation makes me cave because as an arithmetic problem, I don't have the resources to defend this suit to conclusion. Right? Are you following me? It is important enough, if I want to continue in business as a going concern, as a corporation, for me to end the allegations to end the lawsuit, then I will pay damages because I'm exposed to the tune of up to $11,000 per claim over a period of years times 3. You do the math, and really fast it becomes simply uneconomic to do anything except for pay the judgment. So one of Chris's points is when you look at how much the government is collecting up in this business of alleging, I argue not actually uncovering, or certainly not deterring fraud, when you look at the amount that the government is announcing each year, it was $3 billion, that's billions with a B, right? $3 billion last year. Of that amount, $2.5 billion was from healthcare companies. Is all the fraud happening in healthcare companies? Hospitals, pharmaceuticals? Maybe. But unlikely. How come? Why is the proportionate share of fraudulent allegations leveled against healthcare companies? Why are they the targets? Why is that industry being targeted? Well, I think some of it is because of the same reason that bank robbers rob banks. That's where the money is, right? That's where you can find multiple claims over multiple patients over multiple years times 11,000 times 3, right? That's where the money is. And so people, key TAM relators included, go where the money is. There is an opportunity cost, arguably, if I'm right, that there is fraud going on in the defense industry, in the construction industry, and other industries that simply goes unnoticed because that's not where the money is. I'm also concerned, and Chris's note focuses on this, I want to return to the proportion of claims that the government actually intervenes in. Remember, the way this works is a key TAM relator gets to file the claim what's called under seal. And for the period at minimum 6 months that it's under seal, the government looks at it, evaluates it, and says, yay, I want to join you, which is a plaintiff, a key TAM plaintiff's dream come true, right? The government is now your co-litigator with all of its resources. Or the government says, I'm going to sit this one out and let you pursue it to conclusion. And when does the government do that? The government will admit, again, at these conferences where I'm on one side and they're on the other side, the government will admit that we intervene in solid, promising suits that are substantively worth our effort, and the rest we leave to go. So in 1987, just after the 1986 amendments that Chris made reference to, there were 343 cases filed all year under the Civil False Claims Act. 30 of them were by key TAM plaintiffs. The government intervened in none of them. Without the government's intervention, key TAM relators recovered no money whatsoever in 1987. Now, there are a lot of patterns to look at in between that initial start and last year, but let me just go right to last year. Last year, new matters filed, just new key TAM matters filed, a total of 612 new key TAM matters. The government intervened to recover $2.3 billion, right? $2.3 billion. Key TAMs by themselves only recovered $121 million. So if Chris is right, $121 million of cases out of the $2.3 billion total were worthwhile. Right? Now that's not a perfect proxy, but we're talking about 0.05% of the cases that key TAM relators filed were worth the government's attention. That's a really small number. And remember, and this is perhaps because I was a defense litigator a long time before I was an academic, those cases that are not worth the government's trouble, defendants still have to defend them. They still have to hire experts. They still have to hire lawyers. They still have to take time away from whatever their core business is doing and defend those lawsuits, right? So if we really are uncovering fraud and returning money to the public fisc, that's a cost worth bearing, arguably. But there's more evidence that makes me concerned that we are not doing either of those things that Chris set out as the underlying objectives of the Keatam statute. I've written elsewhere to suggest that the fact that what the government recovers, it gets to keep and reinvest in fraud prosecution is no more than bounty hunting. And that's what I think is really going on here. What Chris does a great job of doing is organizing his permissive, middle, and restrictive model in order for me to get a real handle on all the proposals that would modify, that would update, that would change the public disclosure bar and the Keatam statute. Using his three-part model, permissive, middle, and restrictive, what Chris does is organize the various approaches that courts have taken to try to rein these Keatam relators in, to let those who are actually adding value go forward, and those who, to use his words, are piggybacking, not go forward. He also organizes a model that allows us to bring PPACA, what I call PPACA, or the Affordable Care Act, those new revisions in, again, a organized fashion where they can be evaluated. I suggest that there was one more move that you could actually make, Chris, and that is to say, now that you've got this wonderful three-part model, you could use it to look at the content, the timing, and the recipient. Those would be the criteria or the factors that each of these revisions has contributed, and evaluate on that basis whether or not, as the Affordable Care Act does, it liberalizes the timing of disclosures that will be able to proceed, which it does. It liberalizes the content of disclosures that are allowed to proceed and Keatam relators are allowed to continue under, and it liberalizes the recipient, either the government or the original entity disclosing, the initial discloser. I deeply desire that Chris is successful, that courts will listen to him much better than they've listened to me, and balance the type of assessment that he has offered and rein in some of this lottery. Now, to anyone who is listening, I want to go back to this phrase, catch a rogue, use a rogue to catch a rogue in closing. Why do I want to do that? Well, because in my house, we have 3 dogs, and all 3 of them are named after characters in Star Wars. And one of the best analogies to this rogue language is the fact that the Star Wars fighters were called the Rogue Squadron. Now, the Rogue Squadron, for anybody who's a true aficionado, was a pretty doggone fancy group of pilots. They were the best of the best. If you remember The Empire Strikes Back and Return of the Jedi, Luke Skywalker was Red 2. He was a Rogue Squadron, and his wing fighter was Biggs Darklighter. And the head of the Rogue Squadron was Wedge Antilles. Now, those are rogues that you want to be affiliated with, because every time they went out, they destroyed the Death Star. Twice, 2 Death Stars down was a great group of people. I think the government has the sense that it is running a rogue squadron along with these Keatam relators. But even bad guys in Star Wars knew which rogues to affiliate with and which rogues not to affiliate with. Again, if you're a true aficionado, you'll remember that the Emperor stands on the Death Star and responds to the suggestion that Boba Fett be used as one of the tools to go after poor Luke Skywalker, and the Emperor says, we don't need those bounty hunter scum. Now, I know every Keatam relator is not a bad guy, but I also know that there are some rogues you don't want to be associated with. And what Chris has done is tried very hard to clean up the empires and make sure that the bounty hunters are good guys, not bad guys. And I commend you for that. And I'll close by saying, may the force be with you.
All but stands between you and dinner, so I'll try to keep this brief. I'd like to thank you for the invitation to be here and congratulate Christine and Christopher on excellent notes and excellent presentations today. Thank you. Fraud is one of the most serious problems infecting our nation's healthcare system, and I really do believe that. The FBI cites estimates that healthcare fraud accounts for 3 to 10% of the nation's healthcare bill. And I follow several law reporting services every day, and there is a long list of convictions of healthcare providers for serious healthcare fraud. But fraud against government programs also presents an opportunity. One of the most contentious issues in the current debate over the federal budget deficit is how to cut healthcare spending. Healthcare spending make up 21% of the federal budget, and thus, if we're going to get serious about cutting the deficit, we need to figure out how to reduce that spending, or at least reduce the growth in spending. But cutting expenditures in healthcare is very difficult, because if you cut the volume, cut utilization, people say you're rationing. But if you try to cut prices, you meet with stiff resistance from professionals, providers, and suppliers whose income and profit are threatened. Everyone, however, supports eliminating true healthcare fraud. If we can just eliminate fraud, we can cut spending painlessly. One of the primary weapons in the federal government's healthcare fraud armamentarium is the Civil False Claims Act. The FCA, as has been said several times, allows courts to impose treble damages plus up to $11,000 per claim against providers who file false claims for compensation. A key feature of the FCA is its key tam provision, the focus of Christopher Alexion's article. The key tam provision allows a person with special knowledge of fraud to sue on behalf of the government and to keep part of the recovery. The key tam provision raises, however, a central problem, which is the focus of Chris's article. When does a key tam claimant provide sufficiently valuable information that the claimant should be granted a share of the recovery, which can be very substantial, as has been noted. On the one hand, you shouldn't be able to do that based on something you read in the morning newspaper. On the other hand, a person with special knowledge should be allowed to bring a key tam action, even though the government already had some information about the fraud, as long as the relator provides really useful information not previously available. The question as to where to draw the line is the focus of Chris's article. And as he notes, Congress has had a difficult time figuring this out. Congress has fluctuated between, on the one hand, defining the key tam relator standing very broadly to encourage key tam actions, or narrowly to discourage parasitic suits. The courts have tried to apply the tests established by Congress, but have reached mixed results. In the Affordable Care Act, Congress once again tried to answer the question as to where to draw the line. Chris's article is a model law review article. It's clear, concise, adequately, but not excessively referenced, a real problem in law review articles. It's also very timely. It's about law also, and not philosophy, social science, or economics. The courts will soon begin applying the amendments to the False Claims Act, and they're going to have to figure out what Congress meant in its modifications, its amendments in the Affordable Care Act. And it's going to have to figure out the relevance, if any, of the decisions that the circuits reached before Congress amended the statute. And Chris's article lays out an excellent roadmap for them to do that, and I'm certain that it's going to be cited in future court decisions. I won't attempt to lay out his proposal in detail. He did that very well for you. It strikes me as a very reasonable approach, discouraging on the one hand parasitic litigation, while on the other hand encouraging individuals who have genuinely useful information to step forward even after some information about the fraud is already known. While I do not intend to criticize his proposal, I would like to offer two comments to give his article more context. And to some extent, my comments will balance out those of my good friend, Professor Matthews, and we've sort of debated about this for years. My first comment is addressed to the question of incentives to bring a key tam action. While restricting standing to bring a key tam lawsuit discourages parasitic lawsuits, it also discourages opportunistic lawsuits. Thus, one relevant question is whether opportunistic lawsuits are a real problem. Superficially, the incentives to bring a qui tam action would seem to be very great. The qui tam relator is entitled to 15 to 25% of the total, and up to 30% of the total if the government does not intervene, which can amount, and has in some cases amounted, to millions of dollars. Although the payoff of being a qui tam relator can be high, the costs are very high as well, and there have been some studies that have been published on this. Although the statute prohibits employers from taking retaliatory action against a qui tam relator, as a practical matter, an employee who is suing his or her employer is in an untenable position that cannot last for long. Qui tam relators face hostility from colleagues and co-workers who may well view the relator as a traitor, as well as efforts by their employers or former employers to humiliate and to discredit them. And if you sue your healthcare provider as a qui tam relator, you're done in the healthcare industry. If you can get a job anywhere else, good luck to you. Moreover, it can take months or even years before the case is resolved through settlement or court judgment. In the interim, the relator receives nothing from the case and may well be unable to find employment. If the case succeeds in a settlement or judgment, the court must then decide the share of the recovery that the relator can claim. At that point, the relator must win a second case against the government, which will actively resist payment. The relator generally receives the award only long after the relator's life has otherwise been ruined by the qui tam action. Many qui tam relators believe that the ultimate recovery is small compared to the disruption and damages to their lives and the years spent in the litigation. In sum, although the qui tam statute offers significant incentives for relators to bring actions, there are also huge disincentives for doing so, which will in all likelihood cause most whistleblowers to bring qui tam lawsuits only as a last resort. While an original source rule may be needed to discourage parasitic litigation, which is the primary claim of Mr. Alexion's article, it is less clear that it is needed to discourage opportunistic litigation. My second comment is intended to put the amendment of to the FCA that Chris addresses in his article in the broader context of the Affordable Care Act. The ACA represents one of the most ambitious attempts by Congress to deal with healthcare fraud. There are many provisions that deal with healthcare fraud in the statute, and I summarized them in my article, but won't bore you with them today. Just to say a couple of things about them. One of them is many of them were originated with Senator Grassley. This truly is a bipartisan bill, although not everybody wants to admit that. And a lot of the ideas here came out of Senator Grassley, who has long been the leader in Congress in fighting healthcare fraud, a Republican from Iowa. And secondly, a lot of these provisions are intended to be preventive rather than curative, ways to try to keep people from committing fraud rather than to try to root it out afterwards. But it's enough to note that the amendments to the civil FCA are just one part of a comprehensive strategy for addressing fraud that's found in the Affordable Care Act. Virtually all of the attention that the Affordable Care Act has received has focused on its health insurance reforms, but the ACA goes much further in reforming our healthcare system than just reforming health insurance. In addition to providing a valuable roadmap for the courts to focus on in their interpretation of the original source amendment, Chris's article also serves a useful purpose by illuminating another aspect of this landmark healthcare system reform effort. Thank you.